Amy, and good morning, everyone. We are so excited to be here with you today to talk about arbitration. The timing is actually pretty great because Neha and I just landed back in San Francisco last night around midnight after finishing up an arbitration in Chicago. So lots of thoughts on the benefits and potential drawbacks of arbitration, but our focus today is more about how you get into arbitration in the first place, if that's ultimately where you want to be. I'll do just a quick overview about what our backgrounds, what we're going to talk about today, and then we will dive right in. As Amy said, we encourage you to drop questions at any point. It's a lot more entertaining when we get to engage with you guys. So my name's Erin Meyer. I'm a partner at Keker. I have been here for about 13 years and have spent a lot of my time in practice over the years working on different types of cases and getting them into arbitration and then arbitrating them. So that includes commercial cases between companies, employment cases, consumer cases, the whole gamut. And it's been a wild ride because, as we're going to talk about, arbitration has changed a lot and is continuing to change, and the rules around how to get into arbitration. But I'm excited to talk to you about all of that today. Neha.
Hey everyone, my name is Neha Sabharwal, as Amy mentioned, and I've been at the firm for the last 6 years, litigating arbitration issues everywhere from moving to compel arbitration under various theories that we'll discuss today, to defending against mass arbitrations, another issue we will discuss later in the presentation. So have sort of seen arbitration in various forms and enforced the right to arbitration in various forms, and looking forward to discussing all of those with you all today.
All right, so let's go to the next slide. This is a little roadmap of what we're going to cover today. We'll give you an overview of arbitration agreements at a high level, how to implement arbitration agreements that are going to be enforceable, what the potential pitfalls are, how to avoid those. We'll talk through. Then we'll talk a little bit about how you can enforce arbitration agreements if a case is filed in court, how you can get that moved into arbitration, and what, again, what the many pitfalls and changing rules are about that. One thing that we've been seeing a lot of interesting cases on recently that Neha's going to talk about is how you deal with arbitration by or against non-signatories to the arbitration agreement. So we'll dig in on that. And then, as always, there are a bunch of interesting cases that have come out in the last year or so from the Ninth Circuit and the Supreme Court. So we'll just give you an overview of what those courts have been thinking about. So let's go forward. Overview of arbitration agreements. As I mentioned, there are pros and cons to arbitrating. As I'm sure many of you know, I truly believe it's a case-by-case analysis of whether you're going to be better off in court or in arbitration. And the answer is not the same for every case. Some of the benefits of the arbitration, and in some cases the drawbacks, right, is that you don't have a jury and you have a very, very limited right to appeal if you get a bad decision in arbitration. Sometimes that's a good thing. You want to just be done with the dispute, move on, not have it be a distraction to your business. Other times, it's a pretty consequential issue, and not having a right of appeal is a big deal. One quick note on the right to appeal an arbitration decision. In California, under state law, and this is not the same under federal practice, but there is a way to carve out a more substantive right of appeal in arbitration agreements under California law. That's a case called Cable Connection, and it's pretty specific how you write those clauses, but that is an option if you do want to preserve the right to appeal. Another potential benefit of arbitration is you can get some limits on discovery. Third-party discovery is a lot more limited in arbitration. The thing I'll say, I think there is this principle that discovery is going to be more limited in arbitration, but the reality is that often you're going to be with a retired judge who is an arbitrator, and they don't love, in many cases, limitations on discovery. They're used to having a full record, deciding things on a full record, and so yes, on balance, discovery is going to be more limited in arbitration, but if you, let's say you put 5 interrogatories as a limit in your arbitration agreement, unlikely a retired federal judge, for example, is going to enforce that if they think that additional information is necessary to decide the case. One big benefit of arbitration, especially if you've got a high profile issue that potentially has some bad PR implications, is that you can include privacy and confidentiality provisions in your arbitration agreement. Keep the decision out of the news, keep the proceedings out of the news. You have to think about that, what happens after an arbitration award, because obviously things can become public if they get filed in a petition to confirm the award in court. But there are some ways to think around that. On balance, you do get more confidentiality of the proceedings in arbitration. There's some cost and speed benefits in arbitration if you're doing fewer depositions, for example, less motion practice. But obviously, you got to pay the arbitrators hourly rates, which have been going up and up. I want to focus for a second on the big benefit of arbitrations, and that's historically been the ability to avoid class actions. And it's something that I'm sure a lot of businesses and a lot of you have thought about over the years. You don't want to end up in court with a big class action involving hundreds of thousands of class members. The flip side of that is that plaintiffs' lawyers have figured out in recent years how to put similar pressure on businesses by filing mass arbitrations, and that's something Neha's going to talk about. Drawbacks of arbitration, I've touched on a couple of these. I think, in general, we're seeing that arbitration is taking a little bit longer than maybe Congress initially envisioned when they passed the FAA. But it can be an expensive proposition when you're paying JAMS admin fees, for example, and the hourly rates for a retired federal judge. Those can be some. One big thing is this idea of fewer off-ramps before trial. It pretty unlikely you're going to get a motion to dismiss decision or a dispositive motion decided in arbitration. It happens for sure, but there is less incentive for an arbitrator to decide a case before just going to a hearing and hearing all the evidence and making a decision. You get unpredictability and inconsistency with arbitrators. Especially if you're going through a strike and rank process, you can end up with an arbitrator who is a little unpredictable, maybe a little idiosyncratic, and that sometimes can pose some challenges. Then we have no ability to establish precedent, not going to be a public decision, and some public perception and fairness issues about how fair it is, especially in consumer and employment cases, to put folks into arbitration. I'm going to do less speeches like that on further slides, but I think it's important just to have some context around what the benefits and drawbacks are of arbitration as we go through the rest of the slides. Let's go forward. I'm going to talk about a couple of things: principles of contract formation, how to create an enforceable contract, how to modify that contract, what are we thinking about in terms of unconscionability, and some miscellaneous best practices for all of you. Let's go to the next slide. Contract formation, what we're often dealing with these days, as you might imagine, is online contracts, right? So an agreement that is entered into between a consumer and a business, an employer and an employee, or two business counterparts. Often you're reviewing those contracts online. And so what the courts are looking for when they're considering contract formation, and contract formation is almost always the province of the court and not an arbitrator. What they're looking for is some conspicuous notice that a contract is being entered into. So when are you introducing the idea of a contract in the sign-up flow of a website, for example? Is it at a logical place that someone might expect a contract to be brought up? Conspicuous notice of the terms of font in 6-point font is it a 25-page document and the arbitration provision is buried on page 21? Those kinds of things are what we're talking about in terms of whether someone can understand the terms of the contract. And lastly, and I think most importantly, is there some indication that the person entering into the contract affirmatively assents to the terms and the contract? So let's talk a little bit more about what that means. You've probably heard these terms, but there's a range of types of online contracts and a range of enforceability. We start with the least likely to be enforceable. That's a browse wrap agreement. I'm going to show you some examples of these. We move on to modified click wrap and sign in wrap agreements. And then and those are sometimes enforced, sometimes not enforced. And then we get to the gold standard. That's click wrap and even better scroll wrap agreements where someone is specifically required to click a button or a box saying, hey, I see these terms of the contract. I'm agreeing to enter into that contract. Let's look at what these different types of online contracts mean on the next slide. So this is a browse wrap example. If you're squinting at the bottom, the text in the bottom, that's sort of the idea. I would imagine you have terms and conditions in smaller text at the bottom of most websites, linking a terms of use or a terms and conditions. That is usually hyperlinked to those terms and conditions. So you're just getting notice through the website text. You're not required to do anything to affirmatively express your assent to the contract, and your assent to the contract is inferred from your use of the website, and that's generally what those T's and C's say. It's been a long time since I've seen a court enforce a browse wrap agreement. I think you should assume that any terms and conditions put on the bottom of a web page where you don't have to click a box, that's not going to be an enforceable arbitration agreement. Let's look at the next example. All right, these are really common these days. These are modified click wrap or sign in wrap agreements. So in other words, what you're doing in a consent flow for an online contract is you're putting language in saying, by creating an account, by clicking accept, you are agreeing to the terms of service, the privacy policy, whatever the online contract might be. Those are usually hyperlinked, but you don't have to click on the hyperlink in order to agree to the contract. This is an example from Uber that has been enforced in some courts. And I want you to sort of look at the fact that we see terms of service in all caps here. We see a blue and underlined hyperlink. And even though the language is below the register button in that consent flow, it has been enforced. I would say the most likely way to get your sign and wrap enforced is to put that language up above the button, but sometimes that's hard to get buy-in from the business when you're creating the consent flow. It does depend on the court. So let's go to the next slide. And I want to show you, this is another version of a sign-in wrap agreement that has been used by Uber. You can see that here, you do see a little box that says terms of service and privacy policy, but above it, you've got this light gray font that says, by creating an Uber account, you are agreeing to this contract. This is a little bit less user-friendly. You have to squint a little bit more to see what you're agreeing to a contract. And so courts have been split on this version of Uber's sign-in wrap agreement. And this example in particular is from a case called Cullinane v. Uber from 2018 in the First Circuit. And it was not held to be an enforceable contract formation in the First Circuit. I think in the Ninth and the Second Circuit, the district courts did allow this particular example to go forward, but it's always a little iffy when you're using a sign-in wrap. You can't really guarantee that you're going to get it enforced. Let's go forward. This is a click wrap agreement on the left. This is the Dropbox terms. This is an agreement that has been enforced. You can see you have to affirmatively click a box. And if you don't click that box saying you agree to the terms, you can't click the sign up button. The sign up button is not going to work unless you click that box and agree to the contract. And that's really important in terms of how you design. The other thing is You can see here it's got a blue hyperlink. I've had cases before where courts have said, hey, your arbitration agreement isn't enforceable because you didn't use blue font to indicate the hyperlink. You used a different color. That's a little out there, but I've seen it happen. So you want to pick the most understandable and user-friendly design to help a user understand that they're being asked to enter into a contract. On the right, you've got a scroll wrap agreement. I think this is really the most enforceable version of an online contract where you put the actual text of the contract up in front of the user. Whether or not they're forced to scroll all the way through, they have the opportunity, and it's right in front of them, to scroll through the contract before they click I accept. Courts generally find scroll wraps to be the most enforceable version, but click wraps as well, very, very commonly enforced by courts. All right, let's go forward. So one thing that if you're in-house, and you probably know, it's pretty common to need to modify your terms of service, whether that's because of something completely unrelated to arbitration or whether it's to address these annual changes in arbitration law that we're going to be talking about. You got to update your user agreement and stay on top of that. How do you enforce a user agreement that has been modified after someone has accepted a prior version of the agreement? There are a couple of ways to do that. You can't do it by just posting a last updated date on your terms of service page on your website. That's probably not going to be enforceable. Unilateral change of terms clauses that say, hey, we retain the right to modify this agreement at any time, and by using our website, you agree to accept the updated terms, but they've never been given notice that the terms were changed. That's going to be a little dicey. What is typically sufficient in courts is if you send an email to users of your website, for example, saying, hey, we've updated our terms of service. Maybe you include some bullet points about the material changes to the terms, or you include a link to a website that summarizes those changes. I particularly love pop-ups in the app or pop-ups when you're signing into the website requiring a new version of affirmative consent that you can point to in a motion to compel arbitration. My clients tell me often that that's a non-starter for their business, which I understand, but emails or some sort of affirmative assent in the app or on the website is the way to go if you want it to be enforceable. Let's go forward. Unconscionability. Unconscionability in the Ninth Circuit, or if you're practicing in California, it's based on California law. You have to show procedural and substantive unconscionability, and it's a sliding scale. So if you've got substantive terms of your contract that are really, really unconscionable, even the most minimal level of procedural unconscionability is going to be enough for the plaintiff to get over the hump and avoid arbitration. That's going to be where a contract of adhesion on the procedural unconscionability side is going to be enough to get over the unconscionability argument. On the other hand, if you have a very low level of substantive unconscionability, you've got to show more oppressive and surprising terms on the procedural side. So what do I mean when I talk about contract of adhesion? That is very common when you're signing up for a website. You are shown a user agreement or a terms of service that you have to accept in order to use the website, in order to activate that click wrap button we were talking about. You can see mandatory provisions, unilateral provisions. Those are the types of procedural unconscionability things we look at. In reality, there is usually some sort of procedural unconscionability that a plaintiff can point to in opposing a motion to compel arbitration. But there is some good case law saying that these days a contract of adhesion is when users have choices to use other websites, other services, it's not that big of a deal. So there's some case law you can point to on that side. On the substantive side, I feel like substantive unconscionability, there are some principles you understand what you need to avoid. You can't have one-sided terms that apply only to the user but not to the company. On the other hand, you see creative arguments for substantive unconscionability all the time. So you really do have to stay on top of the arbitration law and what what the courts are saying. There are some special requirements for employment agreements in terms of substantive unconscionability, with respect to location of arbitration, discovery required, those things like that. That's the Armendariz case in California. Let's go forward. So best practices, make the contract and the terms conspicuous. I always recommend sort of an upfront paragraph in all caps at the beginning of your terms and conditions that says, hey, this contract contains an arbitration agreement. Here's a hyperlink to the arbitration agreement. You should be aware that you're waiving your right to a jury trial. You can use bold and caps to emphasize the language. All of the types of formation tips that we talked about earlier, those are all best practices. Use click wrap or scroll wrap for your online contracts. Those are the gold standards. And eliminate conflicting agreements. I see a lot of times there are a couple of different versions of a terms and conditions on a website. You want to make sure that there is no inconsistency in terms of the arbitration agreements in those terms and conditions, or that one has an arbitration agreement and one doesn't. That's going to get you into trouble. And when you do a superseding arbitration agreement, you want to clearly say that the new agreement controls. Let's go ahead. We've talked a little bit about unconscionability. Other considerations, you want to think about what arbitration rules you're using. Where is the arbitration going to take place? That depends on whether it is whether it's a consumer or an employment case or a commercial case. Agree to arbitrate a broad class of claims. The broader the types of claims that are encompassed within the arbitration agreement, it's going to be easier to get those claims into arbitration. For example, claims arising out of or relating to the contract, that is a much broader agreement to arbitrate than just something saying claims arising under the contract. Think about your language for waiver of class, representative, and mass actions. We're going to talk about that in more detail later. Courts are super interested in mass arbitration issues right now. Think about confidentiality, think about choice of law. A severability provision is always recommended because if a court finds some provision of your arbitration agreement to be unconscionable, in most circumstances, not all, but in most circumstances, you want to be able to say, hey, judge, you can sever that unconscionable provision about limits on discovery and let us go forward without undoing the whole arbitration agreement. If you have severability questions, that's a much more complex issue than I can get into in an hour, and I want to keep us moving along, but definitely an important consideration. All right, Neha, take it away.
Great. So we've talked a bit about the pros and cons of arbitration generally, and we can move forward to the next slide. We'll now kind of move into how to enforce arbitration provisions and certain considerations around enforcement, including the timing of when to pursue arbitration and the scope of relief to pursue. And we'll also look at all of this through the lens of a specific case study later on. So we can move forward to the next slide. So there is no statutory or court-imposed deadline to move to compel arbitration, but there is a risk if you don't move relatively soon after the litigation commences. And that risk is waiver. In particular, a party that is opposing a motion to compel arbitration can argue that the moving party waited too long to assert arbitrability. And historically, the party resisting arbitration bore a heavy burden to prevail on a waiver defense, especially given the presumptive deference that is afforded to contractual agreements to arbitrate. To establish waiver previously, a party resisting a motion to arbitrate had to establish the moving party's knowledge of the right to arbitrate, that the moving party took acts inconsistent with the right to arbitrate, and the prejudice that was created by those acts. But the Ninth Circuit's opinion in Armstrong versus Michaels, which issued in 2023, remove that burden by doing away with the prejudice prong and cautioned that there is no longer a thumb on the scale in favor of arbitration. And so all that a party opposing arbitration must show now in order to prevail on a waiver defense is that the moving party knew of the right to compel arbitration and that they took acts inconsistent with that right. And we'll talk about what that means more on the next slide. So one way that a party could take acts inconsistent with the right to arbitrate is to expressly disclaim it. And so that might happen in the course of, for example, filing a Rule 26F CMC statement where parties generally discuss whether they've considered alternative dispute resolution procedures such as arbitration. So if you're considering a motion to compel, the safest course would be, in order to avoid an express waiver, is to explain in any of these sort of preliminary, even pro forma filings with the court that you are presently considering arbitrability. But more common than these sort of express forms of waiver is implied waiver. And that can be demonstrated by acts that are impliedly inconsistent with the right to arbitrate, which would suggest a party's intention to invoke the litigation machinery rather than exercise an arbitration right. Now, whether there is an implied waiver of the right to arbitrate isn't a precise science, but courts that have found waiver on this theory have looked at timing. So how long did a party wait before moving to compel arbitration? And more importantly, what did they do in court before bringing that motion? And the most inconsistent act a party can take is to litigate the merits of the case in some way, which typically arises in the form of a 12b6 motion to dismiss, and certainly a request for dismissal with prejudice would seek a decision on the merits. So courts have found that to be inconsistent with the right to arbitrate. Put simply, the more that you are asking a judge to resolve in court, the more likely the risk of waiver. Some other acts that courts have found inconsistent with the right to arbitrate include meaningfully participating in discovery, both serving and responding to discovery, because there are certain limitations on discovery that exist in arbitration that don't exist in court. There are other kinds of acts that are inconsistent with the right to arbitration include submitting joint stipulations, or joint schedules to the court. So for all of these reasons, it's generally advisable to bring your motion to compel arbitration if you are considering one earlier on in the litigation, which you can do even in the form of a 12b1 motion for improper venue. And doing it that way also tolls the deadline to answer a complaint, which has separate advantages. And we can move on to the next slide. So another consideration around moving to compel arbitration is the extent of the relief to pursue. And in light of a recent decision we'll address later on, parties can no longer request dismissal of the litigation pending arbitration, but they can certainly request a stay of the litigation. And one question that remains there is just how much of the action to stay. But fortunately, there is ample district court case law, at least within the Ninth Circuit, holding that the FAA itself mandates a stay of the entire action, even if only one claim is referred to arbitration. And we've talked about the risk with a simultaneous motion to dismiss, but one motion to consider bringing simultaneous to a motion to compel arbitration is a motion to stay discovery. Motions to compel arbitration on their own do not automatically stay discovery. So parties opposing the motion may start to launch discovery requests, notwithstanding a pending motion to compel. So to preserve the right to arbitrate, avoid discovery in court until the judge resolves that arbitration motion, it might be worth filing a parallel motion to stay discovery pending resolution of the motion to compel arbitration. And finally, to the extent that a court denies a party's motion to compel arbitration, that ruling is immediately appealable under the FAA, at least as to federal cases. As we'll discuss in a few minutes, an appeal from a denial order requires a stay of the district court proceedings. Though I will flag that for state court cases, California law changed last year such that an appeal from a denial order no longer automatically stays trial court proceedings, but we'll discuss this more in the next few slides. It's just a distinction to think about with respect to appeals.
All right, so I'm going to talk a little bit about a case study and just walk you through a case called Bielski v. Coinbase. And this is one that started out in the Northern District of California, went up to the Ninth Circuit, went to the Supreme Court, came back down, has been a really messy case involving all kinds of issues related to arbitration. And so just going to tell you the story from the beginning to the end, at least for the arbitration, so you can see an example of sort of the life cycle of an effort to compel arbitration. So this is a picture from Westlaw of just all of the different pieces. You can see how complicated this Bielski case became. And you don't need to try to read it, but I just wanted to give you an idea of how many different moving pieces there were in this case. We can go to the next slide. So this case was filed in May of 2021 in the Northern District of California. This was what is often referred to as an account takeover case in a cryptocurrency, in the context of a cryptocurrency exchange. So this plaintiff, Abraham Bielski, he opened a Coinbase account in May of 2021. And he went through a click wrap agreement where he had to affirmatively click a box saying he agreed to the user agreement, and that contained an arbitration provision. A couple months later, he realized that someone hacked his account, someone got into his Coinbase account, and he said that they transferred cryptocurrency out of his account, and it was unrecoverable given the realities of the blockchain. There was some back and forth with Coinbase that he alleged, and he said he attempted informal discussions, but he alleged that there was no good faith effort to resolve the dispute. Obviously, these are all just quotes taken from his complaint, not any comment on what actually happened in the case. And I should just disclose, full disclosure here, we were counsel in the district court case and involved at some level in the appeals. We didn't argue the appeals at the Ninth Circuit or the Supreme Court, but we do have some involvement in this case. So just full disclosure there. Let's go forward. So what are some of the strategic decisions when you get a case like this in deciding what to do about the arbitration provision? Immediately, we said we're going to move for arbitration. We told the plaintiff we were going to move for arbitration. One of my favorite things to do in cases in federal district court is to get a stipulation that you're going to phase briefing on arbitration and a 12b6 motion so that you don't have to perhaps unnecessarily file a motion to dismiss. Neha made the very good point that you can file an arbitration motion under 12b1 to avoid the need to answer. I get paranoid about the argument that you're giving up any of your 12b6 arguments if you do ultimately have to proceed in court. So I like to try to get plaintiff's counsel to stipulate to phase the briefing. I found that often, unless you're dealing with particularly unreasonable plaintiff's counsel, you can get an agreement like that. And that's what we did in this case. We said we're going to let Judge Alsup in the Northern District deal with the arbitration issues first, and if we have to, we'll move to dismiss later on. The big issue in this case was whether the parties had agreed to delegate issues of arbitrability to the arbitrator. And this is the key language from the arbitration provision that Judge Alsup was looking at in connection with a motion to compel arbitration. You've got this defined term of the arbitration agreement saying it includes without limitation disputes arising out of or related to, and hey, that's that broad scope language I mentioned earlier to get you beyond just contractual contractual disputes in your arbitration agreement. But this is also a delegation clause. It says that we are agreeing to arbitrate questions about interpretation of the arbitration agreement, enforceability, revocability, scope, or validity. All of that goes to the arbitrator and not to the court. Let's go forward. So Judge Alsup denied the motion to compel arbitration in the Bielski case at the district court level. And he, in particular, pointed out some antecedent requirements before a plaintiff could file an arbitration as set out in the arbitration agreement. And that is pretty common these days, a requirement to do an informal mediation with the company before you file an arbitration demand, maybe file a formal complaint with the company in order to try to resolve the issues before you have to go pay all the arbitration fees. Judge Alsup said that that was inappropriate. It required users to jump through multiple antecedent hoops before initiating arbitration. And he said that that was not going to be enforceable. Let me see if we are going to. So let's go to the next slide. He also refused to enforce, or in analyzing the delegation clause in the Bielski case, normally judges are only looking at the enforceability of the delegation clause. You don't, when you have a delegation clause, you don't have to deal with any unconscionability arguments in the rest of the arbitration agreement. But here, oh, I'm sorry. This slide sets forth some of those formal complaint processes we talked about that the judge pointed out and said were too onerous. If we can go forward one. And he said that because Coinbase was not required to file a formal complaint for any disputes it had with its users, and only the users were required to file a formal complaint with Coinbase, that there was a lack of mutuality that was at issue. And this is what I was trying to talk about earlier. So usually you don't get into the antecedent requirements about a complaint process or any unconscionability arguments outside of the delegation clause. But here, Judge Alsup found that the use of the defined term arbitration agreement in the delegation clause allowed him to look beyond the delegation clause at all of the unconscionability claims that the plaintiff had, and he did not delegate those to the arbitrator. Let's go forward. Oh, sorry, back up for 1 second. And at the end of the day, I should mention this, because of the lack of mutuality in the complaint process, in the sort of pre-arbitration filing requirements, because Judge also found there was a lack of mutuality there, he refused to enforce the delegation clause and therefore refused to enforce the arbitration agreement. Let's go forward. So we lose the motion to compel arbitration. What is the next step? At the time, the denial of the motion to compel arbitration and our immediate appeal to the Ninth Circuit did not automatically stay the district court proceedings. At the time, stays were discretionary, and the district courts in the Ninth Circuit looked at whether the appeal raises serious legal questions, who's going to be irreparably or substantially injured by the stay, and where the public interest lies. As you can see, that's a huge amount of discretion. We found that different judges within the Northern District, for example, treated stays very differently. So it really depended on the judge you were in front of, whether you were going to be able to get a stay pending your appeal of a denial of a motion to compel arbitration. Let's go forward. So not only did Coinbase appeal the denial of the motion to compel arbitration, Coinbase also appealed the denial of the motion to stay pending the arbitration appeal, right? So two separate issues. And that issue, whether the FAA requires the district court to stay arbitration proceedings while something is up on appeal as to whether to arbitrate, that went all the way up to the US Supreme Court. They granted cert, and in January of 2023, they issued an opinion which, in my view, really changed the landscape of what it looks like to litigate arbitration issues in federal court in the United States. So the question was whether a district court must stay its proceedings while an interlocutory appeal on arbitrability is ongoing. And the answer under the FAA, unquestionably, yes. So what they're saying is, what the Supreme Court is saying is, because the question on appeal is whether the case as a whole belongs in arbitration or instead in the district court, the entire case is essentially involved in the appeal and therefore must be stayed. And this is really important because what we were seeing from a lot of district court judges before the Supreme Court decision was that they would say, okay, well, we're going to let discovery go forward to the extent you could get discovery and arbitration, even though you've got this arbitrability appeal going on. That is no longer allowable under the Supreme Court's Bielski decision. Let's go forward. Then we had the Ninth Circuit appeal, which went to issues of arbitrability. And what the Ninth Circuit held was that a party resisting arbitration must mention that it is challenging the delegation provision and make specific arguments attacking the provision in its opposition to a motion to compel arbitration. What does that mean? It is putting additional limits, additional requirements on a party opposing a motion to compel arbitration in cases where there's a delegation provision to raise challenges specific to that delegation provision and not outside of the delegation provision and other portions of the arbitration agreement. Let's go forward. And the Ninth Circuit also said that in some cases, when you're evaluating an unconscionability challenge to a delegation provision, the court has to interpret that provision in the context of the agreement as a whole, and that may, in some cases, require examining the underlying arbitration agreement. Let's go forward. But even after saying that, what the Ninth Circuit held was that they rejected Mr. Bielski's argument that the pre-arbitration dispute resolution process, that formal complaint process we were talking about earlier, that establishes surprise because the process is neither hidden nor beyond the reasonable expectation of the user. So the takeaway here is you want to be really careful about the way your delegation provision is written and how and whether it's going to allow a court to look through to the rest of your arbitration agreement and deal with unconscionability challenges. And then also the Ninth Circuit is saying here, hey, you can have some antecedent requirements before you allow someone to file an arbitration demand. But nonetheless, I would always recommend that you be very careful in drafting those. Make sure that they're mutual, make sure that they're not unnecessarily onerous, and think about how a court's going to react to those requirements. Let's go forward. The other thing I wanted to point out here, we've talked about avoiding one-sided provisions, but in this case, the Ninth Circuit said, hey, this requirement that a plaintiff file a formal complaint with Coinbase before initiating arbitration, yeah, that's a one-sided agreement. You're not going to require Coinbase to file a formal complaint with itself. That doesn't make a whole lot of sense. And that a one-sided contract is not necessarily unconscionable. It's something we're going to look at, but in this particular instance, it fails to tip those scales that we talked about to render the provision unenforceable. Let's go forward. So big takeaways after the Bielski case and all of the up and down to the Supreme Court. Now, when you're moving to compel arbitration in federal court, if you have to take an appeal, if your motion's denied, you automatically get a stay. This significantly impacts timing. It makes it easier to predict how a case is going to proceed, even if you have an arbitration argument, even if you have to appeal it up to the Ninth Circuit, which in many cases you do. It potentially changes the calculus for a party trying to avoid arbitration, because it means that even if they are able to successfully oppose arbitration at the district court level, they're not going to get the merits of their case heard until after the appeal. So that changes the dynamic between the parties, especially when you're thinking about settlement. In the post-Bielski cases, there have been some open issues about how this applies in multi-defendant cases where the same arbitration provision doesn't apply. So that's something to keep in mind, but a little bit outside the scope of what we're talking about here today. Go ahead. All right, Neha.
All right, so in some instances, non-signatories, so parties who never signed the underlying agreement with the arbitration provision, may nevertheless seek to invoke the arbitration clause and compel arbitration of claims brought by them or against them under various judicial doctrines. And importantly here, and what this slide is discussing, is still that threshold question of arbitrability and what happens in these circumstances. And that question, arbitrability in cases where a judicial doctrine is invoked, cannot be delegated. The court gets to decide whether to apply a judicial doctrine to allow a non-signatory to invoke an arbitration provision. And we'll talk more about those judicial doctrines on the next slide. So what are these judicial doctrines that a non-signatory may invoke to seek the benefit of an arbitration agreement between other parties? Under California law, general contract and agency principles apply in determining the enforcement of an arbitration agreement by or against non-signatories. So those traditional principles include agency theory, and courts have applied agency theory to bind principles to arbitration agreements entered into by their agents. Third-party beneficiary theory, where a third-party beneficiary non-signatory of a contract may nevertheless compel arbitration under this theory and invoke the contract, including its arbitration provision under the theory that it's a third-party beneficiary to that contract. Veil piercing or alter ego theory. That theory may also bind a non-signatory corporation to an arbitration agreement signed by, for example, its affiliate, if there are allegations that the corporation and the affiliate are essentially alter egos. It depends on the allegations. Again, there has to be an allegation that they're alter egos. Or incorporation by reference, where a non-signatory may be bound to arbitrate with a signatory to an agreement containing an arbitration clause when that non-signatory signs a separate agreement with that signatory that expressly incorporates the other contract by reference. Or assumption. A non-signatory may also be bound if that non-signatory's conduct indicates that he or she intended to assume the contract containing the arbitration clause or any obligations to arbitrate thereunder. But the most common doctrine that we see in these circumstances with non-signatories is equitable estoppel. And typically the fact pattern is you have a plaintiff that is suing a non-signatory for claims that are ultimately bound up with the rights and obligations of the contract that contains an arbitration provision. And under those circumstances, courts might prevent a plaintiff from avoiding arbitration simply by naming a non-signatory as a defendant in the lawsuit. So we'll talk a little bit about that particular doctrine on the next page. So courts will apply the relevant state's law in determining whether equitable estoppel applies. And under California law, the doctrine of equitable estoppel applies in primarily two circumstances. And under those two circumstances that are articulated in the Kramer versus Toyota Motor Corporation case. With apologies, both of these two circumstances are quite a mouthful, but we'll walk through each of them now. The first one being when a signatory must rely on the terms of the written agreement in asserting its claims against a non-signatory, or the claims are intimately founded in and intertwined with the underlying contract. The second circumstance might be when the signatory alleges substantially interdependent and concerted misconduct by the non-signatory and another signatory, and the allegations of that interdependent misconduct are founded in or intimately connected with the obligations of the underlying agreement. So another full disclosure here, we recently prevailed on this sort of equitable estoppel theory in one of our cases, and in our motion, we argued that both of these circumstances were present. This was in a case on behalf of our client Tessel, who we were defending from claims asserted by the company Nutanix, and the Tessel co-founders are former employees of Nutanix, had employment agreements with Nutanix that contained arbitration provisions. Nutanix sued Tessel, a non-signatory of those agreements, but its complaint was replete with allegations about the former employee's conduct. So the court in that case granted our client's motion to compel arbitration and to stay the litigation, holding that both of these two circumstances applied in considering all of the facts in the context underlying the case, the allegations of this intertwined course of conduct between the corporation and the employees, and the notion that the entire complaint would essentially be unintelligible without the interdependent allegations of conduct between a non-signatory and a signatory. that are ultimately bound up with the obligations and rights under the underlying contract. So we'll turn to the next slide and talk a little bit about recent developments in arbitration, starting with the rise in mass arbitration proceedings. Many consumer companies in particular have started adopting mass arbitration provisions in their terms of use, essentially as an alternative to class actions. What mass arbitrations allow is for disputes that might pertain to a large class of consumers or claimants to be resolved in arbitration instead. And arbitral organizations such as JAMS and AAA have devised their own protocols for administering these mass arbitrations. Notably, they don't resolve disputes on a class basis, as with a class action, and instead, the arbitrations do proceed on an individual basis. And so there is a concern here that the simultaneous filing of numerous claims can impose significant costs on companies defending against mass arbitrations, which would incur per claimant fees simply to appoint merits arbitrators, for example, well before the claims are ever adjudicated. And so that has invited some mischief by firms who file these mass arbitrations and essentially use the threat of the filing fees alone to potentially coerce settlements, even where those claims may or may not be meritorious. But companies have started to develop strategies to sort of mitigate the impact of mass arbitration by drafting their mass arbitration provisions in terms of use or otherwise, such as by requiring individualized proof of claims or pre-demand notice of claims and other pre-demand measures. But we'll discuss one example of a company that took those risk mitigation measures potentially a bit too far on the next slide. So we'll talk about the case Heckman versus Live Nation Entertainment here. The background to this case is that it involved plaintiffs in a consumer class action. The plaintiffs were Taylor Swift fans that claimed that Live Nation and Ticketmaster engaged in anti-competitive conduct in the primary and secondary ticketing services market, which inflated ticket prices. And Ticketmaster, in response, updated its terms of use, which instead selected New Era ADR as its default arbitration provider, and it adopted New Era's rules in a move that changed Ticketmaster's protocol from individual to mass arbitration. And the court in Heckman held that the arbitration agreement under the terms of use that Ticketmaster had were unenforceable, but that was based largely on the specific rules that were imposed by New Era, which were very respondent friendly. In fact, New Era is a relatively new entity. It was launched a couple of years ago that by its express terms was a forum specifically designed to provide a critical prophylactic measure for clients' mass arbitration risk. So we'll talk a little bit about the rules that it imposed on the next slide. So in both Heckman and in another Ninth Circuit case that was decided last month, the Ninth Circuit acknowledged that New Era devised these very novel and unusual procedures that differ from the traditional arbitral organizations' rules, including JAMS and AAA. And these unusual and novel procedures were concerning to the courts because they were very respondent friendly. One of those rules required essentially bellwether arbitration. And sorry, I think we got lost on the slides a bit, just making sure that we're on the right one.
Yeah, if we could go back one, I think.
There we go. Yes. One of those rules is the requirement of bellwether arbitration. So bellwether processes begin with a test batch of claimants whose claims are adjudicated first, and then the results of those disputes bind subsequent batches. And in the case of New Era retained the right to unilaterally decide which cases would be grouped in that first batch and in all subsequent batches. And if for example, the arbitrator in the bellwether first batch of cases holds that the delegation clause is valid, that holding would be binding on the plaintiffs in all of the batched non-bellwether cases. And that would be true despite a claimant in a non-bellwether case having absolutely no notice of the bellwether cases. No opportunity to be heard in those cases, no meaningful way to participate. So that was one of the concerns of the court in terms of the respondent-friendly nature and design of the process for adjudicating those claims. Another concern was arbitrator selection, in that New Era retained the sole discretion to replace the neutral appointed in a given arbitration, and also had the power to override a claimant's decision to disqualify an arbitrator. There were other forms of asymmetry in the rules as well, including the appeal rights. So the New Era afforded the right to appeal only when the arbitrator awards injunctive relief. So there was no appellate right for a denial of injunctive relief. And it also permitted the party against whom injunctive relief was awarded to appeal that decision to JAMS. So the arbitration agreement functionally reserved the right to appeal for defendants or respondents. And the other rule that was concerning, among a few others, but the main one that was pointed out by these cases was the lack of discovery and procedural limitations under New Era's procedures. So New Era expressly provided no right to discovery for claimants, and their restrictions sort of bordered on the absurd. So initial complaints were limited to just 10 pages, yet claimants were also required to still cover very detailed aspects of their disputes, including all applicable dates, all parties involved, a very detailed explanation of the nature of dispute, so on and so forth. I will point out, though, that the criticism against mass arbitration here is really specific to New Era. Both JAMS and AAA, the more traditional arbitral providers, they have their own mass arbitration procedures that have not faced the same criticism as yet, but this is still a very quickly developing area of law, so we might see some changes in that regard too. We can go to the next slide.
Okay, we have 2 minutes left, so we have two slides left. I'm just going to finish this up really quickly. As you can see, Coinbase had a busy year in arbitration issues in front of the Supreme Court. In May of 2024, there was a question in the Susky case about an issue where Coinbase users entered into that user agreement, the same one we looked at earlier, when they created a Coinbase account. But then later on, there was a sweepstakes involving the Doge cryptocurrency. And that sweepstakes had its own agreement, its own contract that you accepted by entering into the sweepstakes, which did not, in fact, have an arbitration agreement. So the question that the Supreme Court was deciding was, who decides which arbitration agreement applies when which contract, who decides which contract applies to the case when one of the contracts has an arbitration agreement with a delegation provision? Does the arbitrator decide, or does the court decide? And what the Supreme Court said was, where parties have agreed to 2 contracts, one that has arbitration, one that doesn't, a court decides which contract governs. That is the domain of a court. And then I just want to touch very briefly, we're going to wrap up and get you out of here on time. On the next slide, there's a really important case that came down in 2024 called Smith v. Spizzirri. As Neha mentioned earlier, for many, many years, there was an option under the FAA. If you moved to compel arbitration, did you want to stay the case, or did you want to dismiss the case once it was sent to arbitration? Sometimes there was some strategy for plaintiffs in particular to ask that a case be dismissed if a court did grant a motion to compel arbitration, so that they could try to immediately appeal that order granting arbitration. That was a case, that was the circumstance in a case I had last year, where a court granted our motion to compel arbitration but dismissed, and the plaintiff said, okay, case dismissed, I'm going to take it up to the Ninth Circuit and challenge this arbitration order. Well, in the middle of that Ninth Circuit proceeding, Spizzirri came out. The Supreme Court said Section 3 of the FAA does not provide district courts with discretion to dismiss a case while arbitration is proceeding. If you file a motion to compel arbitration, you have to stay, full stop, no dismissal. It's a little bit more complicated than that, but I'm just going to end here because I'm 1 minute over. Thank you all so much for taking the time to be here with us today. I know we're over time, but if you have any questions or want to chat, Neha or I would be happy to chat with you. So thank you so much.
Thanks, everyone.
Hi, everyone. So I don't see any questions, so we will